Hello friends, welcome back to my YouTube channel, that is Discourse on Law and Politics. So my dear friends, in today's video we are going to discuss a very important case here, and the name of the case is Balaji versus State of Mysore. You all have heard about this case because this is a very important and leading case on this Article 15 clause 4 here. So you can see that the Article 15 clause 4, for that when you start a discussion, this case is a kind of a case which is a must discussion, or it is a must part of the Article 15 clause 4 to be discussed always with the help of this case, that is Balaji versus State of Mysore. So let's see what was the fact of this case and why this case is so much important. So my dear friends, if you are a student of the law, for example, if you are the student of UG, or if you are a student of LLM, or if you are looking for the examination of NET, or if you are looking examination for PCSJ, or if you are looking any other kind of the examination which is based on the law subject, then this case is very much important. So for that you all need to know the relevance of this case. So now you know that friends, this case which is here, it is against the state of Mysore. So at that time the Karnataka was not came into existence, the Mysore was as a state. So what was happened in this case? On 13 July 1962, the Mysore government issued an order wherein 68% of the seats in all the engineering and medical colleges and technical institutions in that states, they were reserved for the three categories of the people. The category of the people was socially educationally backward class, SC, ST. For this category of people, they have made the reservation, and the total percentage of reservation was the 68%. And now this category of SCBC was further divided into more categories, that is backward class and more backward class. So this category of the SCBC, it was in the two categories more, that is the backward class and the more backward class. And thus the total number of the seats which was as unreserved, it was 32% of the seats, where only general candidates can take the participation. So the effect of this kind of reservation which was made by the Mysore government, the general category of the people, the citizen of general category, they are having only the 32% of the reservation, or you can say the open seats, not reservation. So this is how you can find that they have only 32% seats. Now of course it is more than 50%. And one more thing which I would like to draw your attention here, that before this judgment there was nothing like a 50% ceiling. So there was no such limit that it should not go beyond the 50%. So that was not the concept at the time. So now because of that it is going to be challenged, and there were so many constitutional questions was there in this case. We will see what were the major issues in this case. Now Article 15 clause 1, which says that the discrimination can't be done on the basis of caste, religion, like that, you know that. So it is not possible that you can do a kind of the discrimination based on this one, caste and religion. So therefore what you find that, let's see what are the major issues which was before the court here in this case. Okay, let's see here. Now the first issue which was here, you all can see on the screen, the first major issue which was here, that was with respect to that extent of special provisions. To what extent the special provision can be done under Article 15 clause 4. So that means whether the special provision can go beyond the 50%, or it may be within the 50%. So how it should be there. So the first issue which was before the court here, that what should be the limit of this special provisions, whether the reservation should be within the 50% or it can go beyond the 50%. So what is the limit of this? The next question which was here before the court, Whether Article 15 Clause 4 is a proviso or an exception to the Clause 1 of the Article 15 and to Clause 2 of the Article 29. So this was another question was here in this case. So what is the effect of this Article 15 Clause 4? Whether it is an exception or it is exception to 15 Clause 1 or Article 29 Clause 2 as well. Now moving to the next question which was here, that was what is the criteria to identify the SCBC? This is the biggest concern. How to identify the SCBC? What kind of parameters may be there to identify the people of the socially educationally backward class? The fourth question which was here, whether you can divide this SCBC community in the two categories, backward class and more backward class, whether this constitution permits that you can have a bifurcation of the SCBC category in the two categories, more backward class and the backward class. Is it possible that you can have that kind of the bifurcation? That was another question in this case. Okay, so now let's see how the Supreme Court has dealt with these issues, what kind of the observation, what kind of orders, judgments came on these issues by the Supreme Court here, and let's see how it is going to change the dimension of the SCBC's category reservation. So let's see. The first issue, that to what extent the reservation can be there. The court says that under Article 15 Clause 4, the reservation should be a reasonable one. It should not be such as to defeat or nullify the main rule of equality contained in Clause 1. That means, to what extent you are going to give a reservation, it must be of a reasonable one. That means you can't have the reservation where you can give the 100% reservation, or you can't have a reservation where the majority of the seats are reserved for a particular group of the people like SCBCs, SCs and STs as well. There must be some limitations as well. So what kind of limitations can be there? So the court says that when you are giving a reservation in the percentage, that must be like that. It should not be that the reservation should go beyond the 50%. However, the court said that it is also not to predict the exact permissible percentage, but in the most of the cases, the reservation should be like it must be restricted to the 50%. So this is how you can find that the court is not going to predict that to what extent it is permissible, but however, the court made a point here, the reservation should be like 50%. So this is how you can find that the court has made a point here. On the second issue, which was here before the court, whether it is an exception to Article 15 Clause 1 and Clause 2 of the Constitution. Now in this case, the court has said here that the Constitution which is here, it is an proviso and exception to Clause 1 of the Article 15. So it is like an exception of the 15 Clause 1. So this is how the Supreme Court has interpreted this 15 Clause 4. However, later on in the Indra Sohani and other judgments, the Supreme Court has changed its position, and they had said the Article 15 Clause 4 is an enabling provisions. Okay. Moving to the next one, the another issue, how to identify the backward class community. The Supreme Court said that the backwardness must be both social and educational, neither social nor educational. That means when you are going to identify this community of the people, that is SCBC, that community of the people, they must be backward on both the ground, social as well as the educational. It is not like that only social parameter you had taken and you have excluded this educational one. So whenever you are going to have identification for this one, you must have the both kind of the parameters, social and education. Now, whether the caste can be a factor to decide the backwardness. So, what you find that the court has made a point here that when you talk about the Hindu community or Hindu society, you will find that there is a backward class of citizens, and in those backwards class of citizens, they are based on the caste. So the court has made that the caste is also a very relevant factor, particularly in the Hindu community or Hindu religion. But this test, which is here, it can't be as a sole and dominant test. However, the court had said that the caste is a kind of the a factor which is responsible for backwardness because the people are divided based on the caste, but it is not the sole one. The court made very clearly, because there are certain kind of people, certain kind of category of section of society or religion which do not believe in the caste system, like Christian, Jains, Muslim. They never believe in the caste system. So how the people from these religions, this group of the people, they would be the part of this socially educationally backward class. So therefore the court had said that if you will restrict the definition of the SCBC, that means socially and educationally backward class, to only to the caste here, then that would be a problematic for particularly this community of the people, Christian, Jains, Muslims, because they do not believe. However, the caste can be taken into account, but it is not going to be solely basis. So this is how the court has given a definition how to identify the SCBC community. So for this SCBC, the people must belong to the both kind of the backwardness, social and educational as well. Moving to the next issue, moving to the next issue here, moving to the next issue, that is whether the categorization of backward class into more backward class, is it possible under Article 15 Clause 4? The court very clearly denied that you can't have a backward class and more backward class. This kind of bifurcation is not permissible in the Article 15 Clause 4. So further categorization is not possible in this Article 15 Clause 4. One more important thing which you will find that in order to understand what is the definition of the SCBC, how to identify socially educationally backward class, the court made a point here. When you are going to identify this SCBC community here, then in that case, you can also look into the occupation and the place of habitation. It can be also a relevant factors in determining social backwardness, because there are certain kind of the people who are engaged in those kind of the occupations, in those kind of the place of habitation they are living, where they are very much in the backward communities, or they are very much having backwardness. So therefore the court made very clearly, in order to identify the socially educationally backward class, it is not the only caste. Caste is not the sole authority. You have to go with the social backwardness and also the educational backwardness. You can also take into account the occupation and place of habitation. So with this, the court made very clearly, just summarize the entire case here, that is, there is no further bifurcation of backward class into more backward class. There is a limit of the reservation. You can't go beyond that one. The SCBC must be both kind of the backwardness, socially and educationally backward, as well as you can take into account the occupation. However, the caste is one of the factor, but it is not the sole criteria. So this is how you can find this. The court has made the point here. And further, the court says that the 15 clause 4 is an exception to the 15.1. However, the court made change in its opinion later on, that it is not an exception, it is an enabling provision. So my dear friends, I have made this extended videos on this Balaji versus State of Mysore case, so that you can understand the entire discussion which was happened on the Balaji versus State of Mysore. This kind of the questions are being asked in the mains, in the NET examination, in the CLAT, in the LLM preparations. Also, it is a part of your UG syllabus. So I hope that you all have liked this video. There's some problem in my throat. Please bear with that. So I hope that you all have liked this one. So if you are first on my YouTube channel, please subscribe my channel so that you can get more such videos future, and please give your comment so that we can improve the quality of video here. With this note, I am thanking to all of you for watching this video. We will meet very soon with another video.